The idea that there should be a Council of Islamic Ideology is an interesting idea. And what Sarah Holz brings out in a book, very well-researched book, is the provenance of this idea, why it became such an important part of the political and the constitutional debates that we had in Pakistan right at the start of the, right after independence, and how this whole idea of Islam engaging with the political and the legislative process in some sense in order to create an Islamic republic that is a democracy, has taken place in Pakistan over the last 75 years. So this has been a conversation that I would submit has become increasingly more important. The role of Islam in the legislative and the governance structure of Pakistan. And the Council of Islamic Ideology really set the ball rolling very early on, as Sarah Holz reminds us, that after the passage of the Objectives Resolution in March 1949, something called the Board for Islami Talimat was set up. And that really, in a sense, is the precursor of what later on was to become the Council of Islamic Ideology. So the idea was that now that we've passed the Objectives Resolution and we've accepted that sovereignty vests in Almighty Allah and is to be exercised by the elected representatives of the people as a sacred trust, but within the limits prescribed by the Almighty, it imposes certain demands on the legislative process, on what can be done and what cannot be done. And on the same day as the day on which the Objectives Resolution was passed, something called the Basic Principles Committee was set up. And the Basic Principles Committee was then meant to draw upon this Board of Islami Talimat to, as if it were, guide the constitution-making process which was then underway. So we know there was a Constituent Assembly, right in 1947, a Constituent Assembly was declared, and this consisted of persons who'd been elected before partition and independence in 1946, and they were reconfigured, as if it were, into a Constituent Assembly whose primary objective, apart from acting as a legislature, was to enact a constitution for Pakistan. Let me welcome Dr. Asif Iftikhar of the Lahore University for Management Sciences, who's now joined us and who'll be our third partner in conversation this afternoon. Professor Asif Iftikhar holds a PhD from McGill University, if I recall correctly, and is a scholar of Islamic thought in Pakistan and more widely. And now, therefore, you have three conversationalists, one a political scientist, one a mere lawyer, and a scholar of Islamic thought. So we can carry on. So I was just setting the stage for our conversation by reminding the audience of what is the Council of Islamic Ideology and how it kind of grew out of the deliberations of the very early years. Now, we'll talk about this. Why was there this need to have the Objectives Resolution? Why was there this need to identify Pakistan as it came to be identified as an Islamic republic, which could legislate only within limits prescribed by the Almighty? So this whole idea that Pakistan was an Islamic state and therefore it had to, in some sense, do Islam within Pakistan was a conversation that started very early on. And then we see that the 1954 disruption in the constitutional process, whereby a constitutional text that had been approved by that Constitutional Assembly and was to be presented on the 27th of October 1954 was scuttled through the dissolution of that assembly on the 24th of October 1954, just 3 days before the day on which that text was to be presented for its final approval and ratification. Now, what was going on, but we'll maybe not get into that in any great detail. But what we do know is that a constitution that emerged then in 1956, after a new constituent assembly had been put in place, contained something along the lines of an advisory council on Islamic thought, Islamic ideology, and then we get to the 1962 constitution after yet another disruption in 1958, a martial law and a constitution promulgated by General Ayub Khan. And this constitution then created the Council of Islamic Ideology, slightly differently named, along with an Islamic Research Institute, the IRI. And these two bodies then worked in tandem. And during those years, we see there is some quote-unquote progressive Islamic legislation. The Muslim Family Laws Ordinance gets again promulgated in 1961, in fact, a year before the 1962 Constitution. But during the 1960s, there is this sense that we somehow are looking to incorporate some form of Islamic modernism, as if it were, into the legislative framework of Pakistan. Then there is the inevitable disruption in 1969, a new martial law, and then we have elections in 1970, and after that the dismemberment of the country, and a rump assembly that was elected in 1970 is then configured as a new constituent assembly to draft a new constitution. And we end up with the 1973 Constitution, which again provides for a Council of Islamic Ideology and defines its role. So basically, the Council of Islamic Ideology is to advise the national and the provincial assemblies. The national and the provincial assemblies can refer a matter to it, seek its opinion with respect to both proposed legislation and, I suppose, existing legislation, as to whether such legislation violates the injunctions of Islam or not. And the Council can also make recommendations that enable the Muslims of Pakistan individually and collectively to live in accordance with the injunctions of Islam. So it's an advisory body. It does not have power in the sense of being able to annul legislation or to even prevent legislation from happening. But this body, nevertheless, has an important, if you like, emotional role, apart from its more explicit constitutional role. For a law to be declared un-Islamic by the Council of Islamic Ideology clearly would act as something that would delegitimize that law or a proposed law. So within the constitutional framework, you have this mechanism for delegitimizing what Parliament might otherwise have done or might be proposing to do. But we know that now the Council of Islamic Ideology really forms part of a structure of Islamic institutions, and Sarah Holz brings that out as well. Through the 1980s, we saw the emergence of the Federal Shariat Court, again set up by a military dictator, General Zia, after the 1977 coup. So we now have the Federal Shariat Court and the Shariat Appellate Bench of the Supreme Court, which really take way further what the Council of Islamic Ideology could have done, because they actually have power to declare a law repugnant to the injunctions of Islam and to make it ineffective from a date to be specified by them. And the Shariat Court has had a very major impact, I would submit, on our legislative developments of the last, let us say, 40 years now, since it came into existence in 1980. And we can talk about that. So maybe I would now ask Sarah, now that we have these bodies in place, we've got the Shariat Court and the Shariat Appellate Bench, we've still got the Council of Islamic Ideology. Has the Shariat Court maybe stolen some of the thunder that the Council of Islamic Ideology might otherwise have deployed? Over to you.
Thank you so much. Thank you for the introduction, and thank you all for being here today. Before I answer that question, maybe let me just take one step back and also talk about why I looked at the council in the first place. Because I was working in Pakistan and people were telling me about this Council of Islamic Ideology. I was reading about it in the newspapers, and I started asking questions. I was like, what is this body? What is it for? Who are the members? And everyone I asked, I always got a different answer. And most of the answers were very polarized. And so my question was, what makes, because we talk about it as an Islamic or religious institution, but there's still also institutions of the state. So my question was, what makes an institution of the state Islamic or religious for that purpose? Because, I mean, we can see similar institutions in other countries in the world. So that was kind of my starting point, in a way, for this inquiry. And here the idea was also, and that's why I'm just mentioning also political science. In political science, mostly institutions are just looked at as like secular institutions, secular in quotation marks, and therefore, for instance, also religious parties are hardly ever studied as such through an analytical framework. They're very often just disregarded because they deal with religion. And so what I wanted to do also with the study is to say, bring those institutions back into political science as well. And so coming now to also your question, because something that we can see is that we only always talk about these institutions in terms of religion. But one of my main arguments is that they're very much embedded in the socio-political context of Pakistan. So we have to see religion not as a separate sphere, but all of these discourses, these institutions are embedded in feudalism, patriarchy, sectarianism, and so on and so on, all these different patterns of governance and rule in Pakistan. And they respond to new developments. And so I think in the 1980s, what you see in the 70s already with Naqib al-Atas, when he talked about Islamization of law, and this was then picked up in all these conferences, and then basically you have this whole idea, suddenly so you have the Council of Islamic Ideology, and then you have in the 80s the shift to Sharia. So you also see there that suddenly in the beginning, in the 1960s, it was more like Maqasid al-Sharia, so it was more about the overall picture. And then suddenly now you move, also with the Zia al-Haq regime, you move primarily to law. So I think I didn't look in detail into that competition. It's something I say in the book. No one has looked at that competition between the council and the Federal Shariat Court. And when I talked to council members, they said there is no competition. The Federal Shariat Court also said there is no competition, but you can see that there is dissatisfaction on the end of the council, that they are less powerful because, yeah, like you said, the recommendations are not prescriptive, they're just recommendatory, while the Federal Shariat Court can declare laws unconstitutional. I think another big thing or difference also between the Federal Shariat Court and the Council is that the Council also today sees itself as a larger body that responds to the government, while the Federal Shariat Court can also respond to the queries of citizens, because citizens can file Shariat appeals to the Federal Shariat Court, while citizens, ordinary citizens, can generally not access the Council of Islamic Ideology. The Council of Islamic Ideology can pick up suo motu topics from the media, and people could potentially maybe write to the council, but it's within the discretion of the council whether they pick up that topic or not. While the Federal Shariat Court has to respond to an appeal, like a Shariat appeal from a petition from citizens, for instance. So I think there's this difference, and it is again also due to the change in the overall socio-political context and what becomes important and what is not important at a certain point in time. And I think what we see today, again, also globally, is again this trend of Maqasid al-Sharia. So you kind of move back to that larger, less literalist interpretations and also discussions. Maybe not so much in Pakistan, but you see it a lot, for instance, in Malaysia.
Okay, thank you. Asif Iftikhar, how do you look at the Council of Islamic Ideology and its career from, let me say, the standpoint of sacralizing, as if it were, democracy? Can democracy really be sacralized? We hear of spiritual democracy. That's a term the late Dr. Javed Iqbal used to use a lot. So how do you see the role of the Council over the last 75 years as somehow adding a spiritual or a sacred dimension to our governance? Yeah, they should have put, yeah. Okay, maybe you can use this. Thank you.
Thank you, Salman, and thank you everybody for having me here. Um, yeah, my issue as an academic is to look at uh, how much such institutions facilitate discourse, what possibilities of discourse emerge. You know, one is reminded of John Elia's line where he says, "Baat nahi kahi gayi, baat nahi suni gayi." So that itself is a very, very important contribution. I know that the role is confined. There are certain limitations. It does not really fall into that ambit where it can affect changes in law as such. Yet, the idea that there is an institution which made dialogue possible, and Salman was already referring to some changes that were brought about when Dr. Fazlur Rahman, not our Fazlur Rahman, Miguel
Professor
Fazlur Rahman
of Chicago,
of Chicago and Miguel, yes. So, who was finally, declared an anathema for other reasons, not legal reasons. It was a kind of a hermeneutical discussion, a kind of epistemic discussion. But changes were brought about, and they're still in our forms. Dialogue took place. And despite all the vicissitudes through which the development of this institution has gone, there has been an amazing discourse. And that's where, I mean, whatever we have, maybe we can't think of an ideal situation in which institutions will work, but with whatever we have at hand, should also be allowed to work in a way where, as Sarah pointed out, the patriarchal, cultural factors which are not necessarily religious, they come from the discursiveness of the tradition. But at the same time, they might not be religious per se. And I think there are ways of using what I often term as a Weltanschauung or worldview that is very pervasive in the Pakistani scenario, certainly in the rest of the Muslim world as well. Maqasid al-Sharia too doesn't totally escape that ethos, which is, and I have coined this term for lack of a better one, and I call it a logocentric deontology. Logocentric because we are entrenched in the idea that there's this divine word and everything emanates from it, and all the deons, the rules of our ethics and therefore of our law should emerge from that. So that aspect, even when Shatibi was talking about Maqasid al-Sharia, at that time it was not a utilitarian approach. It was more of a teleological approach. Even if you read the works of medieval Mu'tazilites, they will be arguing from the text to legitimize their rationality. So that's the kind of maqasid for which you are still going back to the text. And if that engagement is possible, if people are allowed to speak and go back to the text, and that's where modernism emerges from. Many of the modernists talk about Sir Sayyid or Maulvi Chirag Ali or Dr. Fazlur Rahman and others. Their whole idea is revolves around what one might call the hermeneutics of recovery. They're going back to the text and trying to recover the original Islam. And the important thing to talk about is why is that kind of dialogue impeded and what are the impacts. And despite all the impediments, human thought will still not remain confined. It will still have impact. It will still find ways to express itself. And that's where the role of such institutions becomes important. If need be, we can talk about two aspects that are very important to me. The aspect, one is what I call epistemic, the idea of the confines of the role of ijma as an episteme. I remember once, a long time ago, when I was asked by HEC to start a department in the National Law University, there was a judge sitting in the panel interviewing me with you there, and I was trying to tell him that one has to go beyond D.F. Mullah and Sir Abdul Rahim's lectures to understand the idea of what has happened in Ijma and talk about, and now even Mufti Rafi Usmani, who recently passed away, talked about a different notion that was very close to what Iqbal talked about. So that's something we have to, critically look at. And along with that, the hermeneutical processes which emerge in interpretations of law. And finally, the possibility of what I would term as eclectic pragmatism, the possibility of talfiq, the possibility that was opened up not by Western historians or Western academics, but by people like Shah Waliullah and Shah Abdul Aziz. Those possibilities were open. So there's three things that one could talk about in terms of making this particular role of expressing the diversity of ideas. Because most of you who are in the field of Islamic studies would know, or Islamic law would know, that Islam has never been, in terms of its application, a monolithic whole. If you open up any reasonable book of fiqh, like Bidayat al-Mujtahid, for instance, or Al-Mazahib al-Arba, for instance, the portion where you'll see Ijma Muslimun ala hada, the portion on which Muslims agree, they're very, very confined, maybe 2-3 pages, and that's what the core of religion is. Then Ittafaqul Ulama, also add another 10-15 pages. Khilafiyat, the rest of the manual. So if that possibility is opened up by such institutions, it would be a great move forward.
Now let me pick up on that. What you say is very interesting. You're saying that Islamic law has never been a monolithic whole, as if it were, and what Muslims agree upon, in history or in medieval or earlier texts would also be confined to a few pages. But isn't the entire purpose of a body like the Council of Islamic Ideology and the Shariat Court to really say, this is Islamic law, this is what should be implemented? So once you create a constitutional body with power to, as if it were, decisively pronounce on what Islamic law is, a power far greater than what any mufti sitting in a Darul Uloom would have. This is a constitutional power now, so which has kind of traveled from the Council of Islamic Ideology to the Shariat Court. It is a power to really pronounce upon and to, as if it were, make concrete and exclude other possibilities by way of what is to be implemented in the Islamic Republic. So that idea of diversity and fluidity goes away once you have binding judgments which are to be taken to be the law of the land in terms of what is Islam. Now you mentioned Iqbal, and Iqbal actually considered all of this in his reconstruction lectures, you find. And I'm a little surprised, Sarah, you didn't talk about Iqbal, because he features very prominently in our thought. And he actually thought about something like the Council of Islamic Ideology in the reconstruction lectures that he delivered in 1930. And he asks this question: how is ijma possible in the modern age? And he says that in the modern age, we will no longer be able to oust the Republican democratic spirit. It now suffuses our era. And therefore, he says that going forward, ijma will have to be carried out by elected assemblies, assemblies that consist of lay people, not ulama. So there will have to be elections on the basis of adult franchise, and people elected as a consequence of those assemblies will have to consider in an Islamic polity questions of Sharia and Islamic law, and what will become applicable will be what finds the support of the majority of these lay assemblies. So having said that, in these flowing, effusive pages in the reconstruction lectures, he then pauses. And he says, but of course, the elected assembly will be able to seek the advice of specialized bodies that have specialized knowledge of Islamic law. And therefore, he proposes the setting up of an advisory council in his 1930 lectures. But as soon as he does that, he then turns around and says, but I don't mean anything like what they've done in Iran in the 1905 constitution. There was a kind of a revolution in Iran, and he says, but that bothers me. They've given too much power to this body in the Iranian constitution of 1905. They can practically veto parliament, so I really don't want that. So in a sense, when you look at what we've done with the Council of Islamic Ideology in terms of our constitution, Articles 228, 229 onwards, and I'd urge people to read those articles. There seems to be a fairly fine balance, which seems to draw inspiration from Iqbal's original vision that yes, you have this body, but it will not be able to override or veto what Parliament may propose to do. So there would be a conversation between this body and between Parliament, and ultimately it is Parliament that will decide what is to be Islamic law as enforced in the state of Pakistan. Now that balance then gets completely subverted by the Shariat court, which can override Parliament, which can strike down what Parliament might have done and declare it repugnant. And the other thing that we see with this Council of Islamic Ideology and its history is that people have been appointed to it very often, clearly, by way of political compromise. Now, why else would somebody like Maulana Shirani, who Sarah talks about in her book, and Maulana Mahmood Ashrafi be on such a council? Now, clearly there was some political give and take. Maulana Shirani was a very important leader of the JUI. The government of the day, which was the Zardari-led People's Party government, needed the support of the JUI, and they appointed Maulana Shirani as one of the offerings to the JUI, to the Council of Islamic Ideology. I can't think of any better reason than that for Maulana Shirani being on the Council of Islamic Ideology. And similarly with Mahmood Ashrafi, one knows of his links with the Saudi monarchies and so on. So every government tries to have him on their right side because of his Saudi connections, and he ends up on all sorts of councils and ulama boards and so on. So there's a lot of that real politique that goes on in the governance of Islam, as if it were, in Pakistan, and the Council of Islamic Ideology has reflected all of that. So how much of a real scholarly body is the Council? How much of real jurisprudential, if you like, ijtihad can a body like this actually be performing, which has to look at political expediency, which has to look over its shoulder as well. And you remind us that there was in fact an actual physical conflict between Maulana Ashrafi and Maulana Shirani. They actually went for each other physically in one of the meetings, and the meeting had to be adjourned. So we see that these bodies really reflect what is out there in society. Out there in society, conversations about Islam, about Islamic law, very often do turn violent. Very often they do arise out of a milieu which is partisan, a milieu which is no longer maybe devoted to that spirit of inquiry and research and scholarship, that one dreams of, in terms of, our iconic scholars of the past. So now we see that the whole conversation about Islam and Islamic law is a very political conversation. And one sees that politics being played out in the Council of Islamic Ideology as well. And the Shariat court is not really our topic, but maybe we'll talk about that a little bit. I have some experience of appearing before the Shariat court, what goes on there. So that is my reaction, Asif, to what you've alluded to, the existence of such bodies as somehow opening up conversation about Islam and Islamic law. I would argue that they've actually served to close down conversation, to narrow the ambit of what is acceptable. And at the end of the day, they serve a limiting purpose rather than a purpose that might aid the opening up of conversation and dialogue. I'd like both of you to respond to that. Yeah, please, yeah? So I'm sorry, I'm being moderator plus here, okay? So I'm a participant in this conversation.
I mean, my point, and I agree with you, but I think also, and that was, again, the point of writing this book, is also they are not static, these institutions, and very often they're portrayed as static. And also, Muhammad Kazim Zaman has shown us about the ulama, they're not static. He calls them the guardians of tradition, but the guardians can also change. And so here also the thing is, you see this also because I kind of tracked the chairman and their members and everything. And so there are windows where debates open up, but of course they can also close them down. So, and one of my points was, it's not only the council, it's not only the members, it's the president appoints the council. Ministries, informally, this is an informal procedure, they refer questions to the council. So it's not the council itself, we have to see the council in the context, in relation to what is happening in society, and also other actors like ministries make use of the council to get rid of uncomfortable questions, because they kind of predict what the council will say, so then they don't have to say that. So also they use it as a scapegoat, so the council and everyone, like, they're not free to act, and they're unpredictable ways of acting as well, and that's again something that I think is not considered enough, is these informal referrals that come to the council that are not regulated. It's just an informal practice that is happening, but it's actually really, really important for its work. A second thing that I wanted to also get back to was what you said, Iftikhar Saab, regarding discovering, and I think here one important dimension I would like to add to going back and discovering is there is in that sense no pure authenticity anymore, because there is coloniality and there's modernity, so even sources from 300-400 years ago are read through our prism of today, and I think that's something really important to acknowledge, because it basically means when we make claims, even like now the PTI does with Riasa de Medina and so on, this conception of what it is still a modern conception. It's still not like this authentic how it used to be, because this idea of the state, and this is again also the idea with the Council of Islamic Ideology, it's what I say, it's an autochthonous, so it's a local institution, but it's not a traditional institution. It is a modern institution because it responds to the demands of the modern state, and that's where all these tensions come from, because there are different epistemologies, different ways of thinking and reasoning are coming together in the council, and this is where tensions are created. And as a lot of scholars on modernity also remind us, modernity, for instance, Carol Gluck, that's also what I talk about, she looks at Japan and becoming modern, and she says there's no line that you step over. And so I think it's the same with an Islamic Republic. There's no line and you step over it. It's a process of dislocation and relocation. It's a negotiation, and I think it's still going on up until today. Another thing I wanted to mention, because you talked about Iqbal, I mentioned him very briefly because I make that distinction. I discuss Muhammad Asad in detail, and the reason why I'm doing that is Allama Iqbal published this reconstruction of religious thought in Islam. But what Pakistan adopted is Islamic reconstruction, and it might mean a semantic difference for a lot of people, but it's not just a semantic difference. There's a difference in thinking about it. And so why I focused, for instance, also then on Muhammad Asad and his ideas is because this small manifesto that he wrote as the head of the Department of Islamic Reconstruction, most of the points that he mentioned were implemented in Pakistan. And here my idea was that Muhammad Asad was a white European man who spoke fluent Arabic. So he came to Pakistan, and he came with all that privilege to Pakistan, and he could speak to the elites here, the elites who had also been in the UK. So he spoke a language that they could understand. And so with Allama Iqbal, he was in Germany, he did his PhD and so on, but he was also a philosopher, so he spoke a different language. And Muhammad Asad, he gave action points. And this is also with the council, again, they give reports that are 500 pages long, and they're written in Urdu, and in extremely difficult Urdu, with Arabic loanwords, with Farsi loanwords, all kinds of things. And then they complain that no civil servant reads their reports. But so, and here you see that there are different logics and epistemologies that are clashing, there are tensions, right? Because the council insists on writing 500-page Urdu reports, and the civil servants insist on not reading them because they don't. And so these are these kind of negotiations that I'm talking about. And the last point I just wanted to make is also that, again, seeing it in these cultures of power and governance, because I think in the 1960s, and even now, what a lot of scholars tell me is, oh, it's very easy, we can talk about this dialogue, and it's very easy to Islamize, but they always see it as if it's happening in a vacuum. And I think in the 1960s, this idea of the council, also what Ayub Khan says, is that it's happening in a vacuum where the people don't matter so much. So their idea of democracy was different to the idea of democracy that is happening today, because they were, and you see this in the Basic Principles Committee report as well, there were allegations in the Constituent Assembly that the Basic Principle Committee report was made, they say, in parda, because they were basically some people, and Sardar Abdurrab Nishta was pointed down by others as the culprit, so to speak. And so here you see in the 60s, the ruling elites, they wanted to do everything on their own. And they didn't actually think about the people. They were used to discussions amongst each other, because that's what they were used to from British governance, from colonial government. And so and this is what Frantz Fanon talks about as well, when there's the independence of colonies, so he was working in Algeria, then the foreign ruling elite is just replaced with a local ruling elite, and the local ruling elite uses exactly the same patterns of power and governance as the foreign ruling elite. And the foreign ruling elite, the Brits, they just talked amongst each other. And so the idea also persisted that people don't have to be taken into consideration. And you see this in the Constituent Assembly debates. There are so many people who say, if you have such institutions, it will go into sectarianism. And then there are so many people who say, no, that's not true. And you can see the writing on the wall already of some people who had that foresight. And I think what happened then is that democracy, or at least also these ideas of democratic legitimation, have seeped in more and more. And this is why you have these tensions today, because you have to make these decisions, and you have to have these negotiations in the context. You can't have them in a vacuum and as an ideal, because, and this is, I think, what the discussions and the criticism is always, maybe the ideal is great, but the implementation is lacking. So these were my points.
Yeah. Yes, so what I take from that is that originally, at least, the idea of this Islamic work was an elite project to be carried out quietly behind closed doors. And you remind us that the first chairperson or chairman of the Basic Principles Committee was Allama Sulaiman Nadwi, who was appointed in 1949, even though at that time he had not immigrated from India. He was still running his Darul Uloom in India, and he was appointed the chairperson, and he then emigrates a while later, almost a year later, and comes to Pakistan. And it remained very much an ulama-driven, closed-door project. And the people in parliament who were critical of it, and you highlight the role of Sardar Shaukat Hayat, the son of Sir Sikandar Hayat, former unionist leader, who most eloquently, from what you reproduce in your book, took on the whole idea of this Council of Islamic Ideology, or the Talimat Board, as it then was, and said that you will create a group of quote-unquote ulama who are sanctioned by the state, and the others will be considered kafirs, and what they say will somehow have the authority of the state. So he makes all those arguments on the floor of the House. And you've, from your readings of the debates of the Constituent Assembly, reproduced what Sardar Shaukat Hayat, and he sounds like almost a lone voice. I don't know if there was somebody else. You quote a Congress leader from East Pakistan who joined him. So Sardar Shaukat and a Congress leader from East Pakistan seem to have foreseen what they thought would become the fate of the conversation around Islam and Islamic law in Pakistan. Asif?
Yeah, am I on the mic?
Okay. You can have this.
I think I already have it.
Okay. Yeah.
Okay, thank you, Salman. I really couldn't understand your first question, because, you talked about the final judgment verdict by Supreme Court as binding. Do we really mean binding in terms of a human understanding of the Sharia becoming binding in epistemic terms, or do we mean binding in terms of being an effective law? That's an important question, because if there's a curb on the thinking process, then no, that's negated throughout Muslim discourses, and it's always been regarded as jihad akbar to speak about it. I mean, That's what scholarship has been essentially about. So what I was referring to was that particular epistemic aspect, that there are very few fora, and talking about belligerence, about the aggressive aspect, I mean, that's been there right from the beginning. I don't want to say something that might be construed as a sacrilege, but it's been there. The belligerent aspect has been there right from the beginning, and it has been there not just in the arena of religious discourse, it's been there everywhere, even in the Western world. You know, I was there when in Quebec when this discussion about parda that Sarah was mentioning was there through Parti du Québécois. There was a huge discussion on whether, you know, apart from France, Quebec was the second, part of the world where this discussion began, and the Parti du Québécois had this charter of values where they argued that interpellation of a woman through parda is a negation of our values that we've cultivated over a long period of time. And I could see the belligerent aspect, and maybe there was no pugilism there, no throwing of punches, but when they go yo, it becomes pretty aggressive. And what other fora we have? I mean, I've spent a lifetime discussing topics with ulama and the kind of belligerence that you already have. I mean, I'm reminded of one discussion where my mentor was talking to an alim from the KP, and we were discussing a hadith and analyzing it vis-a-vis asnad and through dirayat, which is the textual analysis. And then very respectfully, my mentor asked the alim, and he said, Maulana, what's your opinion? And he stared back and he said, Tum wajibul qatl hai. So I said, Maulana, for us, through ikhtilaf, a person becomes wajibul qadl, rather than wajibul qatl. So what I'm trying to say, Salman, is that, let me give you another example from LUMS. This example will explain what I'm trying to say. There was a colleague of mine who I got with a lot of emphasis that we should have such a person who was madrasa trained, very well respected scholar. And he would quite often come to me and say, look, Asif, Taimur Rahman, I saw his name somewhere, he's going to teach Marxism. So let's try and curb that voice. And I said, look, this is a university. You want to critique Marxism, offer another course on Marxism. But don't stop voices. Sectarianism is already there. These problems are already there. The realpolitik is already there. There's one forum where people, and of course I would completely agree with Salman. I mean, we share so many similar values, so many similar worldviews. I've known him for many years, though we have not been really in touch, and I've known his father, and I know the values that we stand for. But maybe the stratagem might be different. I would argue that, look, it is in this forum that you had people like Dr. Khalid Masood, you had Javed Ahmed Ghamidi, you had so many other people, you had Dr. Fazlur Rahman, this law about, the tafeez of haqq talaq emerged out of it, so many other things emerged out of it. There was, when Dr. Khalid Masood was deposed, I think he was already talking about this idea of khula, of setting up a time limit, and I remember writing an article on it, the 90-day. And it was set aside, and yet I was talking to a couple of judges who explained that after that, post that discussion, there was a kind of eclectic pragmatism. In fact, there's an article on by Justice Mughal, which explains how judges do try to incorporate those aspects, maybe not through a consistent theory, but that possibility is there. So what I'm arguing for is that these four are there, whatever four are there, baat nahi suni gayi, baat nahi kahi gayi, baat nahi suni gayi. Let's try to make them more effective, because head-on collisions and curbing also create that problem of what my basic rule then is. Because what I want for myself, I have to afford the other person as well. And I would rather have the engagement and have the freedom to speak my voice. And even, this aspect of a movement within the ulama, that's very confined, Sarah, because when Qasim Zaman wrote that book, he was talking about the ingenuity of the ulama to work within the confines of their ijma, right? He's still not talking about the possibilities that have been opened up by people even like Maududi, for instance. Maududi was a person who was atavist, so the liberal side would be wary of him, and yet, in a certain sense, he is as modernist in his approach as maybe Dr. Fazlur Rahman. So the possibility of dialogue, I think, and of discussion is an important one, and of course, one needs to think about how to make it more effective, less affected by the malaise of realpolitik and sectarianism, and of course, powerful lawyers like Salman can think about the modus operandi for that.
Let me take this further. What I meant was, the Council of Islamic Ideology, to my mind, was a very different thing, and that's why I go back to Iqbal, a consultative body, an academic body where parliamentarians could go, obtain views but not be bound by. So it was an attempt, conceptually, or you might call epistemologically, to create some kind of spiritualized democracy. But what we've seen in Pakistan, the progression from the council, which was often seen as not effective ultimately because nobody would read their reports and they'd have no effect, to the Shariat court, I think, was a very significant change. Now let's just look at the Shariat court. So many of the things that the council had talked about, the Shariat court started to implement. And Sarah again reminds us that people like Mufti Taqi Usmani was a member of the Council of Islamic Ideology before he became a judge of the Shariat court and then the Shariat appellate bench. Similarly, Dr. Tanzil Rahman was a member of the Council of Islamic Ideology before he became a judge of the High Court and then ultimately a judge of the Shariat court. So there was this movement between the Council of Islamic Ideology and the Shariat court framework. Now, one of the first things that the Shariat court did upon being created in 1980 by General Zia, actually 79 and then it was recreated in 1980, was to declare limits on land ownership to be un-Islamic. Now, this is a 1980 judgment, Amin versus the Federation. And in 1980, the Shariat court is created. So almost the first thing that the Shariat court does is it brings to an end decades of what was the central plank of the politics of the left in Pakistan. And it says any land reform that might have occurred or that might be sought is contrary to the injunctions of Islam. Sharia disallows taking away of land from anybody for purposes of redistribution. And that judgment then traveled through the decade and finally became a judgment of the Shariat appellate bench of the Supreme Court in 1990, now known as the Qizilbash Waqf judgment. So the original petitioner, mind you, was one Farooq Ahmad Khan Laghari, the first petitioner in 1980, then a People's Party leader, incarcerated, fighting Zia, was also the first petitioner before the Shariat court, challenging the land reforms that had occurred and that had deprived his family of very substantial amounts of land. So the original case is Farooq Ahmad Khan Laghari versus the Federation, and ultimately it becomes Qizilbash Waqf versus the Federation. Again, two very large landowning families of the country became the most important litigants before the Shariat court and ended up with judgments that declared land reform to be contrary to the injunctions of Islam / Sharia. Now, over the same period of time, we see the conversation in Iran next door. So in Iran, land reforms were proposed by the Majlis after the revolution in 1979, enacted by the Majlis, turned down, struck down by the Shura-e-Negahban, which was created by the Iranian constitution as being un-Islamic. Once again, the Majlis enacted land reforms. Again, the Shura-e-Negahban turned them down. So 3 times, land reforms enacted by the Iranian Majlis were struck down by the Shura-e-Negahban, which was not quite a court, but was an upper house that had the ability to veto legislation enacted by the lower house. And ultimately, Imam Khomeini had to intervene and create a third body, Majlis-e-Hal Waqt, to say that, look, at the end of the day, in the Iranian state, it is the Vilayat-e-Faqih that we've created, and the Faqih can ultimately decide the questions of the Islamic-ness, as if it were, of particular legislation, and he upheld the land reforms. So there you had this escape mechanism, as if it were, but we no longer have that escape mechanism. Now, since the 1980 judgment in the Qizilbash Waqf case, land reforms cannot even be a legitimate political demand in Pakistan. Because to make that demand is to make a demand that our Shariat appellate bench has said is un-Islamic, is contrary to the Sharia. So that's what I meant by the closing down of conversation, both political and to some extent academic. You're right, academics can still talk about it, can still write about the legality, the permissiveness of land reforms. But the fact is that land reforms as an issue went out of our political discourse after the 1990 judgment of the Shariat court. I could talk about the recent riba judgment, but that's a far more emotive topic than land reforms, so maybe one will hold back on that. But I'll just point out that there was a major report on riba by the Council of Islamic Ideology in 1979, and then it gets taken up. And the authors of that report were Taqi Usmani and Tanzil Rahman, who then become Shariat Court and Shariat Appellate Bench judges, and give effect to that report of the Council of Islamic Ideology to say that modern bank interest is also riba, which is prohibited by Sharia. Now, prior to that, we had an 80-year debate, starting with Rashid Rida in Egypt, questioning whether modern bank interest was riba or not, and then you had all these people through the decades looking at that. Al-Azhar, in fact, had declared modern bank interest not to be riba in Egypt, and yet in Pakistan we ended up declaring modern banking or bank interest to be riba, and now finally last year we got a judgment of the Shariat court which the government has now accepted, appeal by the State Bank and the government against their judgment to the Shariat Appellate Bench has been withdrawn, and that entire conversation has now come to an end, that yes, modern banking and modern bank interest is indeed riba, and therefore somehow the entire financial system has to be reconfigured. Our relationship with bodies like the IMF and the World Bank, the judgment says that will have to be renegotiated going forward, and a 5-year window has been created. So the conversations around Islam are very real conversations, and they have a very real impact on our governance, on our legislative ability, and on our politics. So that was what I was trying to allude to. So just two last closing comments, and then I think we come to an end. Sarah?
I'll be very quick. I also think, because again, there's always change. So I think with crypto and all these things coming up, I'm 100% sure the riba case will be opened up in a few years again, because things change all the time. So, and it's the same like organ transplantations. The council also talked about this. They talked about IVF, all these kinds of things. So these conversations, they keep on coming up because we're not static in the society. Exactly. And I think that's the important thing, that it's not a static body. And also one point for me, what you, I think, showed so beautifully, the circulation of people. Again, it's inscribed in power structures. And so you see the same people circling through all these institutions. And so it's also important to look at this. And one point of the book was also that a lot of people don't know how these institutions work. There are certain people, when you look at Sharia petitions to Sharia appellate petitions to the Federal Shariat Court, there are certain people who always just one second. Who always file, or who file these a lot. So what is important, I think, for all the citizens is you have to know how the system works. Most people don't know. And so if you know how the system works, you can ask for accountability, you can ask for transparency. If you don't know, then you can't ask for it. And that was also the point of the book, that there needs to be more awareness, because there are certain people who push and who are using these institutions for certain maybe also their own interests, I don't know. And so that's, I think, an important thing.
Asif?
Yeah, just very briefly, I agree with this aspect that this discourse has to continue. And in the Qizilbash Waqf case, if you look at the argumentation, it's almost like a mini thesis. written about
Just a 1,000-page judgment.
yeah, 1,000. And I remember Justice Mansoor Ali Shah, who was the lawyer, and he used to come to me, and we used to have discussions on the argumentations that were given. And of course, those argumentations are not the final argumentations. You would have an argumentation ranging from lillahi mafis samawati wa mafil ard to Allah belongs whatever is in the heavens and the earth, to argue that there should be curbs, to other arguments. So that discourse should not end. Similarly, the case of riba. I mean, Salman would already know that Mufti Taqi Usmani himself had a volte-face in terms of his opinion, on Murabaha, and that's also what facilitated the changes. Anyhow, I'd just stop here because I've been told the next session has already begun.
Okay, thank you very much. I'm sorry
Okay, thank you very much.
overstepped.